Current class is pretty good. The classes are pretty competitive, and this current class is two that have really taken to it, even though they never made a cup of it in their life, and they've done really well. So it's clearly the system's working. So
Right. I mean, it doesn't matter if you can research or write. I mean, the key is, can you make a
if you
good
can't make human
cafecito?
coffee, that stuff is pretty much secondary. Especially if you need to make it for jurors like we do here, which has been a success of mine for over a decade of keeping jurors awake in long trials. So you got to know how to make it.
I love it. I love it. Well, I appreciate that warm up. I guess with that we'll get going. First of all, good afternoon. My name is Marianne Curtis. I want to welcome everyone to, I guess now it's like season 6, episode 3 of the Blueprints, where we're going to be discussing effective advocacy in federal court. And I'm joined by some heavy hitters here today. But before I introduce them, I did want to just take one brief moment and express my gratitude to all of you because, when I started this platform 6 years ago, the idea was that I wanted to create practical, substantive content that is easily accessible, i.e., it's free. And, as this grows, we're able to reach more people. And if we can reach more people, hopefully we can help more people. And, throughout my career, the last 15 years, the greatest joy has been trying to give back to a legal community that has given me so much. And so without you all, that doesn't happen. So just, thank you. I think sometimes that should be said more. And so let's get down to it. I want to introduce first and foremost my co-host today, Jonathan Osborne. So Jonathan is currently the managing shareholder in Fort Lauderdale at Gunster. He's also the president of the Broward chapter of the Federal Bar Association. I also was lucky enough to be his trial partner at the U.S. Attorney's Office. And I asked him to come on because he's a great resource, not just, I mean, candidly for anything, whether it's legal or not. He's usually my first phone call. But I do think he's a great resource when it comes to effectively advocating in federal court. And then the man that you're all here to see, the Honorable Rodolfo Ruiz, fondly and commonly known as the Honorable Rudy Ruiz, uh, does not need an introduction, but he deserves one, so I'm going to attempt to do that. And he began his law career as a law clerk for the one and only Judge Moreno in the Southern District, and then was a assistant county attorney at the Miami-Dade County Attorney's Office. And then he began his judicial career. And the best way, or I guess what I should say, what I find most impressive about Judge Ruiz is his ability to combine intellect, humility, and a work ethic that is second to none, which is displayed through his trajectory and his ability to really, really work and hone his craft all the way from being a county court judge in state court. He was a circuit court judge in state court where I literally watched him roll up his sleeves and get in the trial pits. Trust me, I was there. I watched it trial after trial after trial, just getting reps in. And then he was appointed to the federal court bench, I believe in 2019. And Judge, I think what I was trying to figure out a way to describe you in sort of like the most simplistic way. And the best one that I came up with was this very brief moment of indulgence that I'm going to ask for, and that is, I think it was 2013 or 2014. I was a state court prosecutor, and I took a assignment that nobody wanted. Right, I was supposed to go to Miami Beach Branch Court, and for those that don't know, Branch Court, it is the most undesirable position as a prosecutor because there's no juries. It's meaningful work, but you're really going there for like traffic calendar, and there's like no valid driver's license, and you're like, it's important, but it's not like the sexiest thing that you're doing. And I walked in, and I was like, okay, well, let's just like hammer through this calendar, and in walks Judge Ruiz, and this man brought a level of integrity and order and efficiency to a branch court calendar. And I think in that moment, I realized maybe 12, 13, 14 years ago, what I think everyone else has noticed and or noticed before me, which is we had a star amongst us. So, thank you for taking time out of your busy day. And sort of what we're going to do here, and I'll jump into the material. For those that attended the state court, we did one with a parallel state court last month. We're going to go through topics, and we've prepared topics. Jonathan and I are going to give the practitioner perspective. We're going to be brief. because really what you're here to see and hear from is Judge Ruiz, and he's going to kind of tell us we're wrong occasionally, hopefully. And then we have questions that you all have sent in ahead of time that we're going to pose to him. And really, the point that I want to get across to you all is we have a plan. We wouldn't be doing this without a plan, but we're happy to go off the plan in whatever direction you all want. So put any questions you have in the chat, and we'll roll from there. So with that, Judge, I guess I'll start us off, and I will be brief on this section, and then Jonathan will take the next one. So last month, we did effective advocacy in state court, right? And we did it with Judge Walsh and Judge Arzola, and they were amazing. And the theme there was state court, and this is sort of like the basics, right? The basics of state court that we wanted to get across was that state court does not need to be a circus. And we talked for an hour about different things that we could do in our practices and that they would like to see as to why it didn't need to be a circus. And I'm going to say, from my perspective, my message when I think of the theme of federal court is that it doesn't need to be sterile. And I think sometimes, again, my own perspective, happy to be shot down here, is that sometimes I find that practitioners get so nervous and so ingrained in the formalities of federal court that they sometimes forget that this is still advocacy, and they still have, most of us know who we are as attorneys, and if not, we're figuring it out. And so I guess sort of what I'm trying to say is that I think you need to know who you are as an attorney, and there's a spectrum, right? Like, and I can be intense and passionate about probably watching paint dry, but I don't change my approach based on state versus federal court. I change my approach based on the audience, which is the specific judge. And I find that the attorneys that I talk to sometimes, oh, it's federal court, like, and it's like, it's just a different approach. So I'm interested in, sending this over to you in the sense of what is the message that you think that we all should have in our head as we're, figuratively or literally stepping into federal court. And then I'll have some follow-up questions if it's all right with you.
Of course. Well, first of all, that was such a kind introduction, and it made me feel very old that we're talking about
Me
Marianne's
too.
court from 13 years ago. But it's such a great story to tell because it dovetails perfectly into this subject, which is kind of understanding how to manage a courtroom and the differences between handling it from the state side to the federal side, and how you as practitioners should approach appearing in either forum. And having come from one or the other, there's a lot of state court that I've attempted to take with me, which I think is a lot about what you're targeting, and that is not getting so caught up in the secular cathedral court, in that you lose yourself stylistically. I think without doubt, you have to understand it's a system really of numbers. And what do I mean by that? I mean, when you're a county court judge, you have, 10,000 cases. The calendar is extreme. Circuit court, you're probably on the civil side, 3,000 cases, 4,000, probably more. Criminal, anywhere between 500 to 600 cases. When you get to federal court, not to say that they're not complex and some of them may not be analogous to 50 cases on the state side, but the reality is you now have a much smaller, more focused docket. You are probably looking at anything between 40 secret cases, 200 to 300 civil cases. So what does that mean? A jurist who, unlike my tenure in state court, where I was only focused on whatever was on fire and 6 feet in front of my face because I couldn't look at anything else. Here, I have a sense of everything that's happening on the docket. I know people are filing resources that my state brethren don't have. I have wonderful magistrate judges. And so the amount of preparation and management that we can do on the federal side versus the state side, it's leaps and bounds. And it's a function of the breadth of the docket, the volume, and the resources. And so that means that while you may be more of an on your feet litigator in state court because the venue affords for lawyers to be a bit more fly by night on issues and recognize that perhaps things aren't going to be as fulsomely briefed because it's not the expectation of the culture. That's not going to be the case here. So your advocacy skills have to be the same. But to your point, you must adjust to the fact that you're dealing with a jurist who will probably have the luxury of being more prepared, and that means you need to be more prepared because as opposed to one, you're the only show in town who's been brought in by the court on your 12B6 at 2 o'clock in the afternoon. There's nobody else there. It's you and the jurist, and you're there to focus on your case. And the depth of that focus is probably going to be probed by the district judge a lot more than I could have done when I was in the state bench. So knowing your case is paramount even more. You should know it regardless of the forum, but I think you're going to have a jurist who's probably going to know it as well as you do. Whereas perhaps in state court, you are informing the judge a little bit more than you would over here, simply because the preparation level allows us to be a little more steeped in what you're dealing with and what's going on in the case. So that would be kind of the to your point, when you're coming in, being caught up in the formalistic nature of federal court, right? I mean, I don't want you to come in and be stilted because for whatever reason you are kind of a little bit intimidated or uncomfortable with the setting. And I would like to think that when I have made the transition, the comfort level that I try to establish is the same, even though the surroundings might be different, as what I did in federal court, and it should be like it was in state court here, a conversation. That's what an oral argument is to me. It's more of a conversation than it is kind of a very overly structured argument. And I think maybe some folks come in thinking that it needs to be that way because it's federal court. Our rules, our local rules. You want to address the court properly. You want to know to stand. You know, there is some more formal technique, but it should not change your advocacy style. In fact, it should complement it. And it should, in fact, in my view, give advocates even more strength because you're not in a very busy calendar. You're not in front of a judge who has to put out 4 or 5 fires. You're hopefully in front of a jurist who has more time. So your advocacy can play a bigger role than it otherwise would in a busier calendar, which is much more common in state court.
And Jonathan, you came off mute, so I want to pass it to you because of course Judge Ruiz is on fire and he's already like swallowing the questions in his intro. So I do have a few follow-ups, but Jonathan, do you have any thoughts on this approach either from your perspective or a follow-up for Judge?
I have a follow-up for the court. Your Honor, you mentioned your transition as a judge from state court to federal court. And in the context of your answer, it seemed like you were mostly talking about in a civil context and how the court, if the court gives a hearing, is going to be prepared to talk about the issues. Should litigants who come before you, when you do grant a hearing, come in expecting you to have specific questions for them about the issues, whether it's factual or legal? And what's your advice for lawyers on preparing for that? We don't get the questions in advance. So how can they best anticipate your questions?
Well, first, also great to see you too, Jonathan. I'm glad you're here, Marianne, doing this because I'm so fond of you both. So thank you guys for tag teaming on this one. I think it's a great question. And I can only speak for myself and stylistically how I do things over here. But I can tell you, I'm a big proponent of bringing people in for oral argument. And I, especially in early stages, routinely set motions for hearing. Most of the motions I'm setting are early stage motions. Again, motions to dismiss, motions to compel arbitration, whatever it may be. Certainly anything that is case dispositive, a Rule 56 summary judgment or something that I want to make sure if I'm leaning towards perhaps a grant, you need to talk me out of it if there's an issue of fact that I'm missing, right? And so I want to give the lawyer an opportunity to let me know if I'm wrong or I'm heading in the wrong direction, and that's where advocacy comes into play. But in terms of the preparation, to your question, when I set a case for hearing, it's multi-purpose. It's not simply to hear the argument, it's noticed for the argument, but there is an expectation that it is also going to be a status conference. And so you are coming in perhaps ready to argue your motion, and we're going to argue that motion first. Make no mistake about it. But at the same time, when the motion has been heard and we're done with the argument, the next thing is I'm going to want to know, a little bit about this case. So it's I'll give you an example. It's a personal injury case. I can only divine from the pleadings that an injury was a fall on a cruise ship. I mean, there are falls and then there's falls with a capital F. I mean, what are we talking about? What's your client have an injury? Torn rotator? Did they have, some sort of a concussion? How many medicals? What are we looking at for medicals here? I mean, are we talking about, did they have to go get treatment? What happened with that? In a business dispute, I mean, are you guys still talking? Where are we at now? Have there been any exchange of numbers? I want to know if there's a potential for a settlement. Are we looking at an early mediation? Do we want to maybe get in after I rule on this, after I figure this out, and we get an amended complaint? Or do we want to get in early? Do we need some discovery? Discovery issues, initial disclosure issues. How are things looking? What's the scope of this case? How long do we think it's going to take to litigate? Those are examples of the questions I routinely ask. Some are going to be case specific, but some of them, will apply whether it's a business dispute, personal injury case, trademark dispute, whatever it may be. There's going to be managerial questions that I'm going to want to ask. And I think everyone should be ready, not any different than what you would do in initial disclosures and when you're presenting to the court a joint schedule report. A lot of that is what you're already familiar with, but I may want to get a little more into that, a little more depth into that. And I may want to know more about the case that I haven't gleaned from the pleadings. And so to me, I think that's the familiarity about knowing your case that you need to know. I mean, every now and then you will be stunned to see, and I've had it happen where I'm asking what I would imagine would be very straightforward questions that in intake with your client and meeting with your client, you would probably know the answer to. And every now and then I will get lawyers who haven't really spent the time to dig into their case in early stages and figure out the value of their case. And really, I'm trying to assess complexity and value. Value, because I want to know, is this case going to be one that could resolve early and may not need the court's full attention through the whole life cycle of the case? And complexity is, am I going to have a case that is going to be extremely litigious? Am I going to have a massive class action and I got to do class certification? I wonder where that's going. Those kinds of issues I want to tease out too. But I think that every lawyer needs to come in understanding that we're trying to get a better sense of where you're at in the life cycle of the case and how much energy and focus is it going to require from the court. And I will add as a final point to that, if you're being brought in too and you happen to have been very litigious before you've come to see me, meaning you're on your fourth request for a SIR reply on a very standard motion to dismiss or failure to state a claim, and you're back and forth and can't give me a joint schedule report because you can't sit down in one place and have a meeting confer. Don't be surprised that my hearing on your motion serves a third purpose, and that is to tone set, which is if I see problem children on my docket that early, I'm going to find out what's going on. And we probably need to do a reboot because the lawyers are not getting along and I can already see what's coming. And I'm not going to get into a back and forth when I'm dealing with, I'll give an example, objections for an extension of time of 1 week. And someone says to me in the certificate of conferral that there's an opposition to it. I'm going to want to tell the lawyers, we're going to play fair here. We're going to call it like it is, but let's have some courtesy. Let's keep the case moving, but let's have common courtesy. When it comes to extensions, meeting and conferring, you need to keep in communication with one another. And I do wonder sometimes, and I surmise that this is the truth, that when they come in a court with me, it's probably the first time they've met in person. I bet they've been on a Zoom or they've been on a phone, but they haven't seen each other yet. And so strategically, I'm bringing them in because my strategy is also take a look at your adversary, have a little human connection with me, and everybody know this is how this is going to play out for the next year or 2 years. And so there's a tone setting component of it that I'm trying to convey as well.
And Judge, I'm going to go again. We're going completely off script here.
Yeah, it's a conversation. Yeah, you guys go wherever you want to go.
Okay, because like you're saying things, and I'm like, oh, I got to go down here. I got to go down this rabbit hole.
Sure.
So because my mindset in these sort of platform settings, podcast style discussions with you is, what are the takeaways that the audience can take, right? And how can we then translate that into our individual practices? And one of the things from the lawyer perspective, when you're talking about early, like setting the tone and early discussions, and we're going to continue to mix it up, from the lawyer perspective, so many of us sort of go with the flow of the case. And we all know that the quickest way to get a case to trial is to not prepare, right? The quickest way to get a case to settle is to prep the living daylights out of it. And I guess my question is, for us practitioners that are listening to how you do things, how much of that, knowing what you know about your brethren, both in federal and then also your experience in state, how much of that is guided by your experience of having to manage a calendar that in state court and knowing that, you've got to get these people working, you've got to get these. I mean, it's the good old fashioned Judge Thomas back in state court. He had people back every week to make sure they're talking. So is that more what you're seeing in terms of your colleagues, and that's something that we should be aware of, or do you find that that's more specific to you? And if it's only specific to you, what sort of guidance would you have for us to try and maybe institute that ourselves, right? To get things moving.
Yeah, it's a great question. It's very hard in the sense of it's a culture, it's a chambers and judicial culture issue. I rule like my hair is on fire. And I mean, you can ask every person who's clerked through this chambers, everything about me and the way I was trained as a lawyer, as a law clerk, was speed mattered, resolution mattered. Even in my days in county court, lawyers cared less about which way I ruled, but they needed a ruling. Nothing was more paralyzing for the lawyer in the case than sitting on briefed work, than not advancing the ball, not ruling on discovery issues. Things pile up, and the lawyers have to follow the lead set by the judge. Lawyers can only do so much. You can continue to do your discovery, do what you need to do. The case can be worked up, but at the end of the day, to move it requires a jurist to give you the rulings you need so that you can advance the ball and eventually push you systematically to trial. And I've always felt, don't let, as they say, perfect be the enemy of good, in the sense that if we can get a ruling out, it's clean, it's clear, it advances the ball. It's going to be a reboot because we've got to clean something up in this complaint. It's going to be a denial of summary judgment because, hey, there's an issue of fact. I don't need to write 30 pages if there's an issue of fact. There's an issue. We got to try it. Sometimes you don't want to let the formalistic grandeur of federal court get in the way of just running a clean docket. And that is truly, I think, something that every judge looks at differently. It's hard to say. I would like to think, because I see the statistics, I measure them against other districts. There are, I think, a majority of judges in our district who view the management side of things the same way I do. That in order to get to cases effectively, you've got to move them. And it's not that you're trying to dictate impossible deadlines, although I know, and I remember those days from being where you guys are, that we may strike a hard bargain on some of these extensions. We may be difficult on timelines, but I think that you can still move the case, give some grace to the lawyers. But when you're totally disengaged, it's not going to be the ability to bring everybody in every week. We definitely don't have the luxury, I think, and the bandwidth to do something that focused. But certainly keeping the leash tight, and especially when you're seeing parties that are kicking the can a lot down the road and you need to hold them to deadlines, that's critical. And not delaying rulings that could advance discussions. That's a constant issue for us. I want everyone to understand, when the motion to dismiss comes in and you've already said mediation, I'm looking at all those deadlines. All right, how much time do I got? They're going to go mediate. Do I think I need to crank a ruling out on this because it's going to make mediation better? Sometimes it might not. Sometimes that motion to dismiss, I might not get to it and the case settles, and maybe ruling on it might not necessarily advance the ball. But I'm trying to always figure out where my ruling fits into your life cycle of the case. Am I in a summary judgment? It's going on for a while. It's complicated. Might be a grant. I'm pulling you off the trial calendar. I'm not necessarily going to have you spend time and money preparing exhibit and witness lists and doing pretrial steps. I got it. I got a bomb of a summary judgment. It could be case dispositive. I'll pull that off. I'll pull it off till I rule on it. Might bring you in and argue it. So you have to be constantly aware of where you are in the life cycle of the case, I think, on our side. And it's a little bit of, we're trying to help you, for your clients, figure out what the next step is. And so it is, I think, unique to the judge. I think there's a spectrum. I'd like to think that everyone understands the importance of moving their cases, but I would be the first to confess I'm probably a little more aggressive than others. And I do think that although sometimes it might create a little heartburn for the lawyer, I've always felt like it's better that you get a ruling and we push than you completely pull out of the day-to-day management of your docket and then let the lawyers kind of flounder, because you need to have someone there to give you those targets. Without it, it's really hard to push the case. And then your client is sitting around going, we haven't gotten rulings on this in forever. What are you doing for me lately? And then you guys are caught in the crossfire, and it's really the court. It's not really the lawyer that's to blame for that.
Right. And I guess I did have a question come in about, to the extent that you can, right? We're talking about your chambers. Could you give us a flavor of what kind of happens in your chambers and how you set things up behind the scenes? Because I think sometimes it sort of feels like Wizard of Oz, like what's happening behind the screen.
Sure.
Obviously not, specific details, but just anything so we can understand sort of how things are happening.
Sure. So I think, and I don't think I'm unique in this structure. I mean, my chambers operate with my 3 law clerks dividing the civil docket in a way that's essentially triage focused. Each one has a third, but I want to make everyone understand, at least I goes down over here. Everything is going through me first. So I'm watching the whole docket. And at the end of the day, many times I am flagging for whichever clerk is managing that case issues as they come in directly to me. So there are different ways to do this depending on my schedule. If I'm in a 3-week criminal trial, let's say, something is probably going to come in that a law clerk will flag perhaps for me. But if I'm not in trial and I'm monitoring my docket and my filings, many times I am directing to the law clerk, we're going to grant this, we're not going to grant that, I want you to look at this. And some of that is not because they couldn't do it with time, but the speed, because of the experience, can make a difference and can start the research in the right direction from the beginning. It's my initial read and then delegated for execution. And I've always felt like that assists the law clerk in not wasting time, getting to the right place and bringing me back something. They may disagree with me, they may find something I missed, but at least it gives them a set idea of where I think the answer may lie. And that's constant. Now, one thing I do a lot, and I think this is a state court kind of DNA thing, I use what we call the paperless order a lot, or the unendorsed order. I'm not alone in that. A lot of my colleagues do. Some really use it, and indeed they'll write almost orders through the docket. I've always felt like that could go a step too far because it's really hard as a lawyer, and I experience it, to be reading rulings on the docket themselves. But when it's a couple of paragraphs, and I don't need to maybe be too formal in execution of an order, I try to do it that way. I mean, if you've ever argued a motion to dismiss in front of me and it's going to be granted with leave to amend, the order that's coming out of that is not a 15-page order. It is one that highlights what the deficiencies were in your pleadings and asks you to go fix them so that you have a memorialized record of what you got to go back to the drawing board and amend. But again, does it make a lot of sense to take away time from the docket to draft something that really is not focus more on advancing the case as opposed to putting out more vanity press in the federal supplement? I got plenty of that. I don't need to be putting out more stuff unless I think I need it to go out there. A final order on something, statute of limitations, some issue on summary judgment, those things require a true written order with detail. But there are times, and I think we get caught up in this as jurists, where you can't speak on everything. You got to find spots. I mean, you can, but you'll fall behind. If you want to keep things moving, you've got to pick and choose your spots on where you want to execute and write. And that is dictated by me to my team. If there's something that we're going to write because you know what, that's going to help the next case to figure out Ruiz does this on these. He believes that you should be pleading it this way. He believes this is a 9B issue instead of a Rule 8 issue, whatever it is. Just giving some guidance to the bar, then we write. If I've written on it 10 times and I can cite myself and it's about cleaning up pleadings, we're going to do something that's endorsed. We're going to do it on the docket. We're going to do it fast because I can get that out right away. You can see what you got to do, and it keeps the case moving. And that's why I think in many cases, you'll see a lot of stuff coming from my courtroom in an endorsed fashion or paperless order fashion, because it's just stuff that we can get out there quickly for you guys to digest and then keep the case moving.
Judge, I have a follow-up, and I'm going to set it up. It's kind of a 2-part follow-up to what you just shared.
Sure.
Number one is, when I was coming up through law school and starting my career, I got advice that learning how to write as a young lawyer is an indispensable key to becoming an indispensable part of a team. which is advice that I took to heart. So that's one part of the setup. The other part of the setup is you were describing your orders, some of which are endorsed orders and are shorter. But I've also seen over the years some of your longer orders, and needless to say, you have some personality when you write. And so, two questions. One, who taught you how to write, or what experiences did you have that taught you how to write, that shaped who you are as a writer now? And then, Judge, how do you teach your generations of law clerks to write draft orders the way you'd like, but also to be prepared for their careers after their clerkship ends?
It's a great question, Jonathan. I think the biggest takeaway for me, and you guys have both seen it, is when I was a lawyer, picking up an opinion, and it took me or taking me 20 minutes to figure out what it said. And it was the worst. I mean, I remember as a young lawyer, you would go, I remember going to state court, would quickly print out a bunch of stuff from the third DCA. Hopefully you found some stuff that was right on point. You had it clean, you had it ready. I remember doing the same in federal court, but then every now and then you run into an 11th Circuit opinion that was, unbelievably detailed, unbelievably thorough, but it took you 15 or 20 minutes of digesting it to figure out what exactly am I drawing out of this thing? What is it telling me? What can I use for what proposition in a 50-minute oral argument? How am I going to work this opinion into my advocacy? And so as a young lawyer, I always gravitated towards clean, clear, concise. That was it. The opinions that spoke to me the best. And we all went through law school and we all had to read Learned Hand and we all had to read Holmes. And I mean, if you guys go back and look at that now and pull out your old textbooks, it's borderline indecipherable. I mean, some of those opinions, I don't care how much of the Queen's English they're putting on display, you can't even get through them. It's you're in there like in the jungle with a machete trying to figure out where am I looking for something I can actually take with me. And so that has been the kind of the mantra that I've preached, if you will, for all clerks who worked for me. And even when I was on my own and doing all my own drafting and working through all my own opinions, and of course, practice matters. I am sure that if I looked at some of the stuff I wrote as a county court judge, I would cringe. I bet if I went back and started pulling old opinions, I think I've gotten better. But like everything in our practice, it's the practice of law. The more you write, the more you start to kind of figure out a way to digest and explain things clearly. And so for me, it was what kind of writing did I like? That's where I started. Then it was, as a law clerk, what was I going to do to provide a draft that had that clarity, that when handed to the judge, he would be able to understand our position, he would be able to agree with it, and hopefully would not need to modify or edit it substantially because I hit the marks that he wanted me to hit. And so that kind of evolved. And then I've always felt, less is more. I think some folks think because federal court puts a premium on writing, that produce an opus at every juncture and give us these massive opinions. We are trying to prepare for oral argument. We're going through the paper. So many folks overwrite and they just burden their papers with either case law that's not really on point, or they're just too verbose, or don't give me material that is really relevant for the issues that they need me to decide. And so that same recipe for good transitioning, obviously there's not an advocacy in your writing, but I want it to be approachable. I want you to pick up a Ruiz opinion and go, all right, this is his position on this. He's given us a state of the law. Here's where he thinks it's going, or here's where he thinks it's at based on clear precedent from the 11th Circuit. And now I can take that and I can actually use it. I can apply it. I can use it in an argument. I can work it into a brief. I can suck out a nice parenthetical from it and drop it in. It fits my argument. And that's always been the driving force between our editing process over here is, am I getting too far away from a clean and clear message in the opinion? That vanity writing of just writing, I'm not trying to sound smart for anybody. I'm not trying to put out something that, may have just a lot of wonderful prose, but not any analytical use. It needs to advance the ball, help the lawyers, and put something in the universe that can be actually advancing and helping other cases. And so that's always been kind of the goals or the markers for the things we try to put out. And I just think it's been over time. It's over time. I think the older I get, the more frustrated I get with denser briefing and denser writing, and that I do know, it's that old adage of, it's much easier, quite frankly, to dump all that on the page than it
Mhm.
is to distill it.
Right.
And you get ahead of the game when I can pick up your brief and get through it in 30 minutes and know exactly where you stand. And you'd be surprised. There's a lot of briefing that leaves a lot to be desired on that front.
Thank you,
And
Judge. One thing that I just real quick, Marianne, one thing
no,
that
no,
I
please.
sort of had to learn after I left the U.S. Attorney's Office was sometimes in state court, on motion calendar, as hard as the judge worked to read everything the night before, I might be the 30th case of the morning. And so even if you read it, even if you're prepared, it's impossible to remember the detail of every matter. And so one thing that I've worked into my practice and have taught others to do is to begin your motion with the end in mind, and also to begin your argument with the end in mind when you have an opportunity to go in front of the court to explain the position. And the judge may still not remember every detail that we put in our brief and the footnotes on page 10, but in the 5 minutes aside that we have, sometimes less, really leaving the judge with enough information to at least give an inkling of where they're headed can help move the case along. Another preparation thing that you talked about earlier, Your Honor, was how when litigants are before you, you may have questions about case management, even if you're there on a substantive hearing. And so one tip that I've learned, in particular in state court, but it happens sometimes in federal court too, is to be familiar with the docket, all the pending motions, have a sense if the judge asks of what deadlines are ahead, and also to be prepared, just like you said, to tell the court what are the important issues in the case, how much of the court's management do we need to bring the case to resolution, however it will be resolved, and to always um, demonstrate candor with the court and a respectful relationship with opposing counsel.
I would agree with that. And you know how you know if your motion was a good motion? Because you see your motion replicated as an order.
Right.
That is how you know. And I remember as a young lawyer, the most gratifying moments in federal court were knowing that some judge that I appeared with his law or her law clerks was able to utilize and repurpose my motion as the ultimate order. So that is what you people need to remember, that you want to have your writing, especially if it's something significant and it's very well briefed. You want to give the judge ammunition. Whatever you're giving that judge, he or she can take the cases to the bank. It's clean, it's clear, it's concise, and can be repurposed. And that takes time to develop the ability to be advocating, but also give the bones or structure of a ruling in the advocacy itself. And if you do that well, trust me, the proof is in the order. I mean, you will see turns of phrases that maybe you put in your motion replicated. And that just means that you were persuasive enough that you carried the day based upon how you position yourself in your briefing. And that is the ultimate compliment when you see that. It means you did it the right way. And so I would urge lawyers that when they see that something they have produced and filed generated the ruling that they wanted and sounds strikingly similar to what they advocated, take a look at what you did and replicate that. It's like you have a great golf swing and you want to keep remembering it in your mind. I mean, it's the same thing. If you have a brief or two that hit, there is something about the way you structured it that you should stick with stylistically, because you are making the advocacy particularly effective in that the judge is able to follow your roadmap and essentially adopt it. And that has always been, to me, the best writing. It's the writing that I can digest quickly and that gives me the tools I need to turn the case around. If you give me that, you are putting yourself and your client in the best position to succeed.
I think you both nailed it, so I'll move this along. But I do think the best piece of advice I ever got was from Judge Bloom, who told me that you'll know you wrote well if you've essentially gotten the order and the order is your brief, right? And so, I guess this question, because then I'm going to go to, we have some questions in the chat, which people are very interested in AI, and we are going there. But I'm curious, Judge, is there anything, and what people have asked, is there anything structurally right? When you talk about when you get a brief, or I think this is also carries the day in oral advocacy as well, in terms of how you learn, right? How you like things. Because I know for me, I set up oral arguments very similar to what Jonathan said, which, I mean, it's the end in mind, and then it's making sure there's some sort of very clear formula, so to speak, about how I'm approaching that. And it's usually an elevator pitch, something to grab. It's then explaining the facts in a very quick manner. And then it's what's the hook in terms of to grab you. And then I'm bringing it all together. And it seems basic, but it's not done very often. And people don't come in with that. So I'm curious, both on the writing side as well as the oral advocacy side. A lot of a lot of mentors of mine said, you need to figure out how your judge learns. So
Mhm.
as it relates to you, is there any sort of guidance or feedback as to how you tend to absorb that material?
Absolutely. I mean, I think it's reflected in my opinion style. I am a very big believer in structure. It's probably one of the biggest things I teach law clerks when they come on board is the structure of the opinion really matters. It cannot be narrative. It cannot simply be a flowing level of prose. And why is that? Well, think back to my earlier comments about the opinions we all love the most. They were beautifully structured in that when I'm at oral argument, I could go to subhead 2 because I needed that piece. That's the opinion that I needed for that argument. And so I've always felt like that's what I'm giving back if I write with structure. Someone can go straight to what they need. Maybe I had a really nice legal standard that the lawyer wants to use. You can go straight to my legal standard or my section 1 that deals with one particular discrete issue. And that is what you're drawing from the opinion. Having subheadings, having structure, allows the opinion to flow for the lawyer that's digesting it to understand what each part is advancing argument wise. And I think the same then should be reflected in the briefing. I think that, you want to have a flow in your structure of your arguments. And I think you need to know to lead with your strongest and don't overwhelm. Don't overwhelm in the kitchen sink approach to every argument either. Because what happens a lot of times is you've got a winner in bullet 1 or 2. You're going to go, we have 3 points, Judge. Here's what they are. I'm going to take them in turn. And you obviously have them prioritized in a certain way so they flow well and you're leading with your best. The opinions are also, in many times, in my mind, going to be structured the same way. And I think the same thing with oral argument. If you're going in there, you want to have a game plan that emphasizes your best arguments, your winning arguments. Be ready to concede if you've got something that's weaker and you don't need it. It only shows to me that you're an honest broker and it gives you more credibility. And so structure to me is everything. I think it's very hard to digest opinions that don't use or make use of subheadings. And there's a balance. You don't want to have, little I, sub B, don't go crazy, but you definitely don't want to have just kind of entire blocks of text without a breakup or a flow that lets me consume it faster. And remember, at the end of the day, I know what a Rule 12b6 standard is and a Rule 56 standard is. Don't burn 3 pages giving me the summary judgment standard, right? Don't give me 5 pages telling me what a shotgun pleading is. Cite Weiland, I know what it is, I use it. Give me one parenthetical and let's move. I think people they're loading up the front end, and by the time I get to your analysis, I've been, in a deluge of general pleading standards that I should know by now how to apply. You don't need to be spending too much time on them. Just give me the standard of review so I know I'm in the right ballpark, and then let me cook with the rest of the brief. But that's part of the problem is folks, I think, they don't come in with a blueprint or structure, and then it slows down the flow of my ability to digest the material and know. I want to know what your case is about. I want to know why you're going to win, and I need it up front. Don't bury the lead on these things. The same way I try not to bury them in my opinions. You're going to know right up front if you win or lose. You're not going to the last page. You're going to know right up front, and then I'm going to tell you why. But I don't want you to sit there and be agonizing trying to decipher what I've written.
Yeah. Yeah. So, Judge, I think where we should go, because as precise as you are, we try and be as precise. We're going to end right at 1, because I know you got things to get to. But so I would like to use the last bit of time. Jonathan, I'm going to kick to you for AI. But before we do have a question about, is there any discussion about creating some uniformity amongst the Southern District, the district court judges? Because it seems like you're hard charging, right? Because that's your DNA and that's your culture. But that's sort of the question that we have from the audience is there any discussion about consistency in terms of case management? I mean, I guess outside of the local rules, right? So
Yeah, I mean, it's a great question. It's I could say unequivocally no. There, everyone has the same Article 3 commission over here, and being chief over here is like herding cats. God bless Chief Judge Altanaga. I don't know that you could ever, because it's so uniquely DNA and management vision driven, that you could ever get everybody to buy into a certain way of attacking the docket. I think, every judge has their quirks, for better, for worse. And I certainly think there are best practices. I will say that when we have new judges on board, we all share everything. I know I do. So I know that I'll give you an example that when Judge Artout joined the bench, he received every Ruiz manual, every Ruiz form, every draft of everything I've done. And it's the same thing with any judge that's joined the court since I joined in 2019. Of course, though, it is up to that judge how much they want to implement. And if you're a really eagle-eye observer, you will see trends through certain judges. You will see things that Altanaga or Moreno do that Ruiz does. There are some of us that approach things similar, and then you'll see some things in management that they do that I don't do. So it's really hard to standardize the system. I think we try our best to share internally what we think is most effective. I will say the one arena where I think more and more we do share and we do work together are the way we manage specific kinds of cases. So, for example, if you're seeing omnibus style orders or screening orders that appear to be used by all of us, that often has been generated by one judge who finds it to be a way of case management that is successful. It is shared. And if it works and everybody agrees, you will see mass adoption. I can think off the top of my head, our Fair Labor Standard Act order, which requires the exchange of time records. That was something adopted many years ago, and almost every judge, I think, uses that. So there are exceptions, but by and large, culturally, it's very, very hard because everyone's kind of has their own style.
And it would make these conversations a lot less fun.
That's
So there we
true.
are.
Well, to your point, Marianne, you said it, right? You got to also know your judge, right? So
Yeah.
so a lot of what I'm saying is going to be, I think it can be extrapolated to any practice, state, federal, any judge. But there are certain things, certainly about my comments on management, that I think might be unique to me. But I will say everything we've discussed on oral argument technique and writing technique, I think is universal. And I think any judge on my court would agree with me that that's how they prefer things to be delivered and prepared when they're analyzing your cases.
Sure. All right, Jonathan, take it away. The people want to know about AI, so give the people what they want.
Sure, happy to. So, Judge Ruiz, I know from when you and Judge Moreno visited us at the Broward chapter of the federal bar, you've had some run-ins with lawyers who irresponsibly used AI. So that's the first part of our prompt. The second part is what insight do you have as to your views on the responsible use of AI by practitioners and by judges?
Look, it's a great question, and if we're not adopting it and we're not learning how to use it, we're fumbling on the advances that AI is bringing every day. But we have to be measured and we have to be extremely careful. I mean, we've all been using some sort of intelligence engine since we got on Westlaw as young baby lawyers. I mean, we've all been working with a universe of data that we've been trying to filter, search, and digest and then present. So I think AI is but an extension of this. The concern I have, and you pointed it out, it has happened, and I'm not the only one. Several of my colleagues also have gone through this, where they have seen phantom cases, or as we say, AI hallucinations in the briefs. Certainly it adds a level of stress for us. We've been checking everything we've been getting since day one, because I joke that there have been AI hallucinations before AI, and you both know, because how many times have you read a parenthetical that has nothing to do with a case you're citing? So this is not new that we've had to check exactly what we're being told by the lawyers, but it does put a little bit more pressure on us to really triple check that things we're seeing stand for the proposition that they're being advanced for. And that is always a concern, and even heightened now. I think you can use it in a very responsible way as a starting point. My belief is AI can cull the universe down. It can give you a better sense of an arena of law that perhaps you're not as familiar with. Or perhaps it's a financial product that's a subject of your litigation and you need a quick and dirty search on it. I think AI is perfect for introductions. It's perfect for giving you a baseline. But when you want to actually utilize AI in briefing, I begin then to have kind of an alarm going off in that, sure, it can try to maybe draft something or put something together, but our oaths require the responsibility and buck to stop with us. We can use it, but if we're not patrolling and checking what it's spitting out, I mean, some of this is garbage in, garbage out. These large language models don't that are perhaps using it to initially generate briefing because of its temptation to create things or make connections that aren't really found in the law. I do think it's a great starting point for everything you want to do. And I think it's a good ending point. You can feed it things. It can perfect writing. Maybe it catches a mistake. I think in that sense, similar to what we do with a red line tool, it can help you in catching things after. But if you're delegating too much of your work to it, I think it can take over. And I do think, I've said this to clerks also, there is something to be said about the old school way of finding the cases that Westall says they think are on point and going through them yourself and reading them. And even if not, they don't necessarily hit the mark, you are absorbing knowledge every single time you do research and you prepare something. If you're giving that away, if you're giving away and you're outsourcing that learning of reading cases, you are doing a disservice to your own development as a practitioner, because all of us know we get better with every case we read, every case we try, everything we write about. If you're giving away swaths of what the analytical component of our profession is, you're not going to get any better. You might get it faster, but are you really learning and getting any better? And so I would caution the young lawyers, part of the learning is going through having to read these cases and figure out which ones apply. And the AI can try to do that for you, but you're going to be leaving a lot on the table about your own development. And you should be thinking about it, if not because you're afraid of your license, at least selfishly with your own development. It should be a driver for you to be very careful in how you implement it when it comes to drafting things that you might be filing with the court.
You know, I was very interested to see where you go with this, because knowing your sort of DNA, I think it's interesting perspective, right? Because from a practitioner standpoint, I've become obsessed with this concept of intellectual honesty, right? Because I think it can make us lazy. And
Yeah.
I think the same way that I always at least advise lawyers to at least consider not taking their completely typed out opening statement up to a jury, because it creates a crutch and almost kind of clouds your vision, is the same way I say, well, I don't know about drafting an entire first brief, because it takes away sort of your intellectual honesty and your creativity.
Yeah.
With that said, I'm in complete alignment in terms of a jump off point in terms of the research.
I
Knowing that
think so. Yeah.
knowing that your clerks are, you're churning and burning over here, how much does it play in terms of in your chambers? And do you leave some autonomy to the individual clerks, or do you have sort of rules and regulations as to how much they can use it?
uh, uh, Rules and regulations is it's not being used. That it's that simple. If you watched maybe 6 months ago, 8 months ago, there were a few colleagues of mine who had opinions go out the door that had hallucinations or AI work in there. And I can guarantee you that the vibe in chambers after that was not a good one.
Yeah.
I've been very clear from the beginning as AI has creeped into our profession that in these chambers we are using our tools within Westlaw, and we do have some AI components. I serve on the Judicial Conference of Committee of the United States for Court Administration and Case Management, and I'm one of a number of judges who has allowed authorization of some limited AI capabilities within our Westlaw programs so that we can test run them and see if it helps us at all. But really, they're mostly for research purposes only. No AI comes into play in drafting at all. And so for us, if it's a part of a feature in research components to help us find the correct case faster, or allow us, for example, we can now submit briefs into some of these engines and the engine can tell us is the stuff that's being cited right or wrong? That's a huge advantage for me to submit things that may look a little off to save me time. But when it comes to drafting, there is no implementation of AI, and it would not be acceptable for me to allow any clerk to utilize it at all. So my rule is we don't draft with it. We don't use anything outside of what our research programs have built in, primarily Westlaw, and that's the only way we really use it.
That doesn't surprise me at all.
It's just and I gotta say I hear these stories of overwhelmed state dockets of which I was a part of, and the temptation is real because I can imagine it's going to start filtering in about, well, what if we just throw this into the AI engine and it starts giving us answers and helps the judging component. There is a very distinct human element of the judgment that to me I think is lost with the AI. And so I will be trying to hold the line as much as I can on letting it creep into the judicial making function. I worry about that a lot. I think for both of you, you are very blessed in that as trial lawyers, I continue to maintain, and I've spoken in a conference about this recently, nothing in the AI space will ever replace the advocacy in a courtroom before a jury. I maintain that we will never be displaced in that function at all. It cannot be replicated. The humanity you need to cross-examine individuals, to make connections emotionally to a jury, I don't think that can be replaced. I think it's going to be in research, but it's the drafting right now where the rubber hits the road, where I think we're all a little wary of it. And I think especially smaller firms with less resources have the temptation the most. And that's where I'm the most concerned that corners are going to be cut. And unfortunately, I've seen it.
I think that's right. So with about 2-3 minutes left, I think I have said enough. I want to pass it to Jonathan, and then I want to give you, Judge, the final word.
Sure.
First, I want to thank both of you. Jonathan's been a very dear friend of mine for a long time, and actually somebody I consider not just a great friend, but a colleague and a mentor of mine. And Judge Ruiz, you already know how much and how fond I am of you and your career, and it's just incredible. So with that said, I'm interested from both of you in terms of the takeaways from today. When we talk about effective advocacy in federal court, what message would you want to leave our audience with? And Jonathan, I'll go to you first, and then Judge Ruiz, you'll close us out.
Sure. Go ahead.
Thanks. And Marianne, thanks so much for this opportunity. And Judge Ruiz, thank you as well for being here.
Sure.
I'll keep it concise. My takeaways are: know your audience, begin with the end in mind, and stop talking when you've made your point.
And he's going to stop talking.
Those are all excellent, Jonathan. I would agree with all of those. I think they're great. There's a lot. I hope first, let me just echo Jonathan's comments. Thank you, Marianne, for putting this together. And it's always an honor to be on these panels with the two of you. You know how highly I think of you guys and the quality of the work. And you're that next generation of the profession that came up really with me, not too far ahead in terms of kind of our arc. So it's always wonderful to see you all leading the way here, and that's how it should be. And I'm hopeful. I know I can't really see how many people are on this chat, but I hope folks have really been able to listen to you both because you've had a lot of success, and I've known you your whole careers, and I think you've done it the right way. And folks are hopefully going to take a blueprint away from this. I think for me, the biggest challenge, and it's always just top of mind, and we've talked about this, and I've talked about this with Marianne and with you, Jonathan, is, being light on your feet. I think going back full circle to Marianne's first opening comments about state and federal court and coming into federal court and maybe coming in with some intimidation or nerves due to the formality that maybe is not as present in state court. You need to still be the same advocate. And what that means is you cannot, as you pointed out earlier, Marianne, with your statements in the opening statement coming on a piece of paper in front of the jury, you cannot be so scripted when you come to court, state or federal. I think that folks are coming into federal court sometimes assuming it's going to be super structured because we are perhaps a little more aggressive on rule following and our local rules and our procedures. And so it almost, in some ways, impacts the litigants where they come in almost too buttoned up, almost too structured, almost too wedded to whatever they think they got to come in and do. And if, for those listening that know that we are many times using this opportunity to meet you, to get a sense of the case, to get a sense of where we are in the litigation, and ask questions beyond what you're there to argue, you need to maintain flexibility. You cannot be too rigid in what you're coming into federal court to argue. You must stay on your toes. And I think that's somewhat counterintuitive, because I think most folks think that's a state court thing. I'm in state court. It's a little more rough and tumble at times. And that's where that stuff might come up. The curveballs might come up. But the reality is federal court should be no different, in that if you get there and the judge is taking you to a place that he or she wants to go, you got to go there with the jurist. Don't try to stick to the script. Many times folks come in, and in the first 5 minutes, you're going to know why I brought you in. I'm going to tell you. I tell you where I'm at sentencing, no less. I'm here. You're going to tell me why we're going somewhere else, because I believe that it's more helpful for the advocate, but more importantly, it's more efficient. I want you to focus on the things that I think the whole case turns on. So if there's one case that bothers me, we're going to talk about that first. I've already read everything. We know where we're at. I got the lay of the land. And so my biggest takeaway on this is you just always know your case, but maintain your flexibility. Certainly when you're coming into oral advocacy in federal court, maintain that flexibility and take the read from the judge. Know where he or she is going. Your best bet for your client is to follow the judge into those arenas where he or she is concerned, and tell me why I shouldn't be concerned. Or if I'm going to an arena where the case is going to help you, follow me there and tell me that I'm in the right place and that I should follow that case to an end result that favors you. You have to work with the court. Don't work against the court. And I think sometimes folks don't have that give and take, and it impacts the effectiveness of their advocacy. And I think if you keep that in the top of your mind and don't get too stuck, we say, like, write how you argue, trying to keep yourself with that flexibility, it really will help. Don't lose yourself simply because the venue or the forum might be a little bit different. But I thank you guys for inviting me, and I hope this has been helpful for those watching, give you a little bit of a view, I guess, of how at least things operate over here. And that will hopefully make for better advocacy when you come to court here on the 11th floor in 11-2. So thank you guys again for inviting me.
Well, Judge, you knocked it out of the park. And to answer your question, it was quite the turnout, and that had absolutely nothing to do with Jonathan and myself. So,
oh no, well, the three of us could have a conversation. We quite. Let's be honest. Quite frankly, the three of us could have done this without an audience at all and had a great time for an hour.
Exactly.
Anyway. So I don't really need to see anybody else. But I'm glad that it was a testament to you and the outreach, and that this series has been successful, is having a great audience. And I'm honored to be a part of it. And I really do hope that this was something everyone found to be useful. And you guys, as always, did a beautiful job here, kind of bringing, I think, to the forefront the issues that most advocates need to discuss and need to know. That's why these types of events are so important. So thank you.
Well, we look forward to the next one. All right.
Thank you, guys. Have a great day. Thank you, everybody.
Jonathan.
Thank you.
See you.
Bye-bye, guys.